Hello and welcome to Indianomics. In the Essar Steel versus RBI case last week, apparently RBI and the banks won. The Gujarat High Court allowed banks to take Essar Steel to the bankruptcy court. However, it added some crucial sentences in the judgment, and I quote, that such filing of an application for insolvency in the NCLT would not amount to admitting or allowing the petition for insolvency without offering reasonable opportunity to the company. The adjudicating authority, being the NCLT herein, needs to decide on its own, based upon factual details, whether the insolvency petition is required to be entertained or not, unquote. The Insolvency Code, however, was far more strict. It said that when the NCLT receives a petition, it has to check on only 3 points. 1, is there a default of more than 1 lakh rupees? 2, is the form from the creditor complete in every way? And 3, is the insolvency professional duly registered? And are there any disciplinary proceedings against him? If these conditions are fulfilled, the court has to, in 14 days, summon the creditors and the borrower and appoint an insolvency professional. So, the question we are asking today is not the 14-day timetable in the Insolvency Code sacred? Can the bankruptcy court reject the petition of the banks against, say, Essar Steel or any other defaulter? Can the resolution of Essar Steel and other cases get delayed in spite of heading to the NCLT? To discuss this issue, I have with me Behram Vakil, founder partner AZB and Partners, Sandeep Parekh, founder of FinSec Law Advisors and former ED SEBI, HP Ranina, the well-known corporate lawyer, and RS Luna, partner, Dhaval Vasunji Alliance, and also, of course, former ED at SEBI. So actually, we have 2 former SEBI professionals over here. Gentlemen, thank you very much for joining me. Well, let me start with you, Mr. Luna. The quote which I presented to you clearly says that the filing does not amount to admission of the petition, and goes on to say that the NCLT can decide whether to entertain it or not. Can Essar Steel use this now to actually wriggle out of the NCLT proceedings and demand that banks have to go and consider the resolution which they were trying to hammer out?
Well, you see, the court has tried to reason out that all provisions of the bankruptcy code are not mandatory. And the NCLT is at liberty to consider it or view it as a directive.
Okay.
In the sense that NCLT is supposed to pass the order considering the facts and circumstances of the case. Now, what question you are posing, that if the borrower is raising question on the admission of petition, besides the other 3 points which you indicated, that which are the standard as per the bankruptcy code, I think NCLT will be required to look at those points also and take a view whether this petition should be admitted or not.
No, my fear is that Essar will obviously read this out to the NCLT. Now, NCLT obviously in ranking would see itself, would see the High Court as superior to it. So, Sandeep, do you think this can pose a major legal roadblock? The High Court, after all, is superior, and this might be seen, might be used by companies, litigants like Essar Steel, to drive home the point that is this to be entertained at all, and ad initio another case starts.
So, Lata, you know, I saw the entire order carefully just a few hours back, and I think there is some cognitive dissonance there. And when I say that, what I mean is that what the High Court seemed to be doing was they were trying to just basically say that these are this is a rule of law requirement. It's a natural principle of natural justice. They've not said that, I'm just interpreting it, that you have to hear somebody before you pass an order against them. And on the other hand, you have the insolvency proceedings, which are supposed to finish in 180 days, which basically say for admission, at the admission stage, only these 3 requirements which you listed out need to be met. It's not really, they don't really talk of application of mind. So
exactly.
I don't see them as kind of completely apart from each other. Obviously, there'll always have to be application of mind. Just because there's a 1 lakh debt doesn't mean you wind up a company. But at the same time, you know, the High Court is only, I mean, they've not given any free passes, I think, to the petitioner, which is Essar Steel. They've essentially said that NCLT has to follow whatever procedure it has, which has been put in place, and they also look at 35A and B of the RBI Act, and they say RBI is well qualified to give these directions. So I think I don't see a problem for RBI, but I understand where this question is coming from, and it's just probably the High Court is probably just trying to reaffirm principles of natural justice as opposed to saying that NCLT will have to do things which otherwise it is not required to do.
Okay, Behram, as an encouraging sign, the day after the Gujarat High Court judgment was passed, the same Gujarat NCLT admitted the petition of, if I'm not mistaken, Alok Industries. So the NCLT has chosen to admit it within 14 days and, you know, go ahead and ask for the names of IRPs or insolvency professionals. Yet, can we expect this as the consistent behavior? For instance, in Hyderabad, the NCLT has given a generous amount of time to the borrower for a hearing. Are you worried that this judgment of the Gujarat court can allow inordinate delay or at least some delay?
No, thank you, Lata. I think you have put it really well in your introductory comments that what the law says, what IBC says is very, very clear. So I'm still optimistic that this should not create much delay. Of course, between NCLTs, some may move a little quicker, some may take a little more cautious approach. Each individual is different. That's in every walk of life. So, but so far they have really done an extremely good job. They have figured out, you know, what the law is trying to do, that there is a direct correlation between time and recovery, and 180 days is a very tight time frame. Even the 9 months is a tight time frame, and therefore I think most of them, as I say, have done it in a timely manner, and I don't think that this judgment should make that much of a difference, because once again, you know, they have said natural justice, of course, no question that has to wait, but the 3 points that need to be ticked off don't take that much time.
Exactly.
So whether it's 14 days, yes, can there be a week or so of slippage? Certainly, that can be there, because unfortunately, in this case, as you are also aware, the third point about the IPR is slightly contentious, so that may lose us a few days. But overall, I don't see a change in the way NCLT is handling it, which is the right approach.
Okay. Well, so far not. But Mr. Ranina, could some NCLT in future, or even in the Essar Steel case itself, get dragged? What's your sense?
Well, there is a certain amount of dichotomy in the judgment. Judgment is in the self-contradictory, because it on the one hand says that they will not interfere, the RBI and the banks have the right to file the petition. At the same time, they say it should not be treated as an automatic admission. But the IBC itself provides for a certain procedure.
Yes.
Now, whether you want to call it automatic or not is a different matter. But the procedure of the IBC has to be followed. And if those true conditions are satisfied, then the NCLT has to proceed with the matter. And I don't see why this type of, you know, additional point should be brought in, saying that you once again consider, because then obviously you are going to delay the whole process. And the very fact that the banks have brought in the suit, that they're satisfied that the company is on the verge of liquidation and is a fit case for the IBC to be applied. So I think there's a certain dichotomy in this judgment of the Gujarat High Court. But if the parties to the petition are accepting this High Court judgment, then to some extent they will have to follow it, unless they go in appeal and get the Supreme Court to pass an order. But if they're going by the judgment of the High Court, then obviously the Essar Steel will take full advantage of it and try to press home the point that they should be given sufficient opportunities to prove that they have a proper package, a revival package, and restructuring is possible. Now that goes into the very root of the problem, and I don't think this is the intention of IBC.
Okay. So there is still a very real danger that the case could get delayed.
Well, there would be, I mean, some delay. I mean, of course, it all depends on the NCLT. If they're prepared to say that, look, you can't raise the whole issue de novo and ask us to consider whether on merits, whether there's a fate case for bankruptcy proceedings to be initiated. So surely NCLT will say that and should say that, because they are bound by the law. And if the High Court judgment is to a certain extent contrary to the law, then I think the law must prevail and the NCLT must say that, well, we are bound by the law.
Okay. Let's hope that this is how the case will be treated at the NCLT, but that's the first hurdle. The second one, and Behram referred to it a little obliquely by saying that the insolvency resolution professional issue also in the Essar case is could be a bit of a tangle, since two banks want different professionals. But Essar has gone even further and said that appointment of an insolvency professional in a complicated and complex company like Essar can actually result in serious disruption in the company. Will the court take that charge very seriously and delay or even avoid the appointment of an insolvency professional? Should it avoid an appointment of insolvency professional? Those questions after a very quick break. We are back.